Live.
Hi, welcome to the House Judiciary Committee on this last day before crossover, Friday, March 13th. And we're going to start with H 606.
I can't.
And we're going to have,
Work with my stylist.
we're gonna have Eric go over the latest draft, which only changes in one place from yesterday, and that's adding a petition process. But you're here in case there are any questions on the other language. In fact, you can probably just talk about that petition process, and we can see if anybody had any lingering questions regarding the new language yesterday. How about that?
Sure, sounds good. Whatever.
Expedite things a little bit.
Yep. So Eric Fitzpatrick with the Office of Legislative Counsel, here to chat with the committee about the latest proposed amendment to 8606, which is the Act relating to firearms procedures. As the chair said, hopefully what everyone has in front of them is version 3.1. Is that correct?
Yes.
All right. So this version only contains one change between 3.1 and 2.1. And so to start with, I'll direct the committee to where that change is, so you can take a look at that, and then ask any other questions you may have after that. But we'll start there. And that is on page 7, lines 7 through 9. Now, what's going on here? Remember, this is the portion of the bill that expands the list of prohibited persons. In other words, under state law, the persons who are prohibited from possessing firearms. And it expands them specifically with respect to some, but not all people, who have been committed by a court with respect to a mental illness. So that's the group, the universe of people that we're talking about. Again, that is a subgroup of the folks who are, by virtue of mental illness, prohibited from possessing firearms under federal law. So this is a smaller group than that, but so in that sense, it's a subgroup. But nevertheless, if you are a person who would be covered by this language, then you would be prohibited from possessing firearms, sometimes indefinitely going forward. That's the first group, lines, subdivisions 1 and 2, page 6. And the second two groups, page 7 and 9, not prohibited permanently, but only for the period of time in which the commitment order, the mental health commitment order to the Department of Mental Health is in effect. So when the order is no longer in effect, then you wouldn't be a prohibited person. So that's the universe that we're talking about. The new language on page 7, lines 7 through 9, has to do with an existing Vermont statute that was put into place 10 years ago or so, what's known as the petition for relief, a petition for, often referred to as a rehabilitation of firearms rights. The federal government the Congress has one of these in federal law. Many states have them. This was passed concurrently at the same time that the legislature passed the prohibited persons law generally back in 2015, in part because federal firearms assistance money in connection with the National Instant Criminal Background Check was tied to states making sure they had this process in place. So before you could qualify for this federal money, the feds had a provision in federal law that said, well, you got to have an ability of people who have been at some point in time prohibited from possessing firearms to petition the court and say, for whatever evidentiary reasons they may present, that they are no longer a risk, their mental illness, that would no longer cause them to be a person who should be prohibited from possessing firearms, and they can try and make their case, and the court would make the decision. So that's the process that is proposed to be included. In other words, so you've got this list of folks who would be prohibited from possessing firearms either temporarily or permanently, depending on which category you fall into. And this makes clear that this prohibition doesn't apply. If you're a person who has filed this petition for relief with the Family Division, and they've granted it and said, the court, has granted it and said, held in response to the petition that you should have your firearms rights restored. So it's, in some sense, you didn't have that language there, it might be somewhat ambiguous because you'd have these two statutes on what if someone had filed a petition and the statute didn't say anything about what impact they would have on this language. So kind of nice to have clarity, I think, one way or the other, just so people know.
Questions on that, Zach?
Thank you, Chair. Eric, just curious if there is a similar petition in criminal court as there is in family court.
No, it's all,
It's all family.
yep, exactly. Yep.
That's my question.
Yep. Absolutely. All
That's
right.
what I went on today.
Yeah.
Angela?
Thanks, Eric. My question is like, about, just want to make sure that I'm following. So the, subdivision, so I'm looking at page 7, lines 7 through 9. Page 7, line 7 through 9, yeah. B, subdivision A, big A. So that brings us to page 6, line 9, right? Carrying a dangerous weapon. Or we're at, no, of this subdivision 5, so rather we're on 15, line 15.
Correct.
5A, Romanet.
Yes, thank you, Romanet.
Okay.
Well done.
So this refers us back to subdivision A of this subdivision 5. But, and so it's everything in there.
Right.
That's what that points back is to, like, if there's no specificity or of like a subdivision or a
It
subsection.
includes everything. Yep, exactly.
Okay. Okay, that's great. And then, just a curiosity here. So we have 5A, Romanet 1, and then Roman numeral 1 and 2.
I think Roman numeral, that's what I'm
Roman
going
numeral
with.
1 and 2.
Yeah.
And then we switch back to, then it's Roman, okay, I get it. Romanet 1, Romanet 2 and 3. Yeah, okay. I just wanted to make sure that all made sense.
Yep, you know, so the idea is that if you have been prohibited from possessing firearms for any one of those reasons, but then afterward you got your firearms rights restored by a court order, then that prohibition doesn't apply to you. That's the idea.
Teaching from relief. And what about? We haven't said that there's necessarily a court order to restore rights when you're no longer the subject because of the way that's the phrasing in Romanet 2 and 3 is the subject of.
Yes, but you wouldn't need one.
You don't need one.
Right, because at that point, the order is no longer in effect and it doesn't apply anyway.
Right, okay. All right, I'm just gonna go with it because but I was like, I just wanted to make sure that it actually applies to all of the conditions that we put forward there, so. All right.
Yes, I mean, in a practical reality, it does apply to all of them, but if you imagine a Romanet 2 or 3 situation, say someone that's prohibited from possessing firearms while the relief from a lease order is in effect. So practical reality is that person within that 6-month, 1-year window really going to file the petition? It may not happen all that often, but the option is there. It's up to the court.
And O&H can be renewed and renewed. I mean,
Yeah, they can go on.
that happens.
Yep.
So it kind of covers it. The unlikely or the not very often scenario that comes up on.
Right. Yep, they would be included.
Yeah, we did.
So I have one lingering question.
I don't want to trip.
No, you're not. I don't know. I was just gonna ask if you have any thoughts on something we heard yesterday about the potential benefit of stating explicitly that in the case of Romanet 2 and 3, that the rights are restored when the person is no longer a subject of an order of hospitalization or non-hospitalization.
I think the problem with that would be if you look, for example, on page 6, lines subdivisions 2 and 3, subdivision 2, line 3 and 4, and subdivision 3, lines 5 to 7. That's the language that we use in other places where it's subject to final release order and it's the same consequence. And then when the order is no longer in effect. So if you were going to do that, you would certainly want to do it there because otherwise it would be interpreted to mean something different.
Yes. Okay.
So my general approach would be that's the way it's worked under these other two. So no reason to necessarily add language.
Okay. Thank you.
Yeah,
My only question is, so on the new additional wording for the petition for relief.
Right?
So looking at that 13 VSA 4825.
Yep.
So subsection A1, the first section, a person who is prohibited from possessing firearm by 18 USC 922G4 may
Mhm.
petition the Family Division of Superior Court. So someone needs to be prohibited under that federal statute to file a petition.
Right.
So is the idea here that everything in 18 USA 922G4 is also covered in here? So when someone files a petition because they have been revoked from being able to have a firearm under this statute, that it kind of is the same thing as 18 USC 922, and so they are essentially equivalent, and so they can move under that, they can petition under that one, and it will apply here.
Yes.
Okay.
Yeah. Because that statute, even though it's broader, would include everything here anyway. So I think you would.
Yeah, and it's like automatic. So if they're kept from having firearm in this statute, it's going to also mean that they are prohibited under the federal statute, and so they'll be eligible to file that petition if sort of like the means in which they learn that they are not eligible to have a firearm right now is through this statute.
Yep.
Okay.
You're right. Yep. So yes, everybody who would be prohibited by this proposed Vermont legislation is already prohibited by federal law.
And so we don't need anything in 4825 that's like explicitly saying that you can petition for your firearm back if you are prohibited under this statute.
Right, because that's already.
Because it's okay.
Yeah.
I just wanted to double check. Great.
Yep.
Thank you.
No, I agree. Yep.
Any questions about any of the other parts of this work here? All right, so we're going to go to John, but before we do, I forgot, and I apologize completely. There had been a motion on in the committee yesterday, actually was with the draft number 2.1. And
I'll take a moment to address the committee. So I really appreciate the conversation I had with the chair last night and the private dialogue that we both had about the bill, and I think what could be a great path forward for us, chair and members of the committee. So at this point, I'll rescind the motion to report the bill adversely for version 2.1.
okay, great.
Yesterday.
So now we're on 3.1.
Yes.
I apologize, I didn't do that before.
That's quite all right.
3.1.
I appreciate the dialogue we had yesterday.
Okay, all right, thank you. So we'll turn to John Rose. Thank you for your availability and flexibility this afternoon. There were some questions about constitutionality, and I did realize that some of the members in here haven't heard really much about Bruin and how we look at these bills. I may have been a little presumptuous thinking that, oh yeah, this looks like we have very good arguments, but that's because I've been dealing with Bruin since it came out. So if you could give us that background and tell us what you think of this bill as far as do we have strong arguments or not, I appreciate, but obviously introduce yourself first. Thank you, John, for being here.
Thank you, Chair. For those who don't know me, my name is John Rose. I'm the Solicitor General at the Attorney General's office. And in that role, I'm sort of responsible for overseeing defense of constitutional litigation against the state, including Second Amendment issues, First Amendment issues, challenges to state statutes are sort of primarily what I do at the state level, and appeals at the Vermont Supreme Court, the Federal Courts of Appeals, and the U.S. Supreme Court. So I understand that I was asked over here to speak a little bit about the Second Amendment analysis and give some sort of general thoughts on H 606, I believe it is. I've written 505 in my notes, but I think it's 606. Yes, thank you. So let me just start with a little background. I don't want to bore everyone with a law professor talk, but I do understand that there's been a lot of changes in the law in the Second Amendment area over the last 15 years or so. It was in 2008 that the U.S. Supreme Court first recognized an individual Second Amendment right. And since then, there have only been 3 major Supreme Court decisions that have sort of fleshed out that right. So there's quite a bit of uncertainty about how that analysis works still at this point. The most significant of the cases that's come out so far is the Bruin test. That's New York State Pistol and Rifle Association versus Bruin. That was decided in 2022. So we've only really had a clear test since 2022. And that test, it's not like the test that we use for a number of other constitutional rights. So it's still sort of being fleshed out a little bit more in the courts. So a lot of the issues work their way through the lower courts. There are decisions on those, and we start to get a consensus as to what's allowed and what's not allowed. So the basics of the Bruin test it's a 2-part test. The first is we look at a piece of legislation and we decide, is the conduct that this legislation is attempting to cover, is that something that's protected by the plain text of the Second Amendment as informed by the Second Amendment's history? So that means, the Second Amendment has to do with the people having a right to bear arms. And so we need to look at whether something covers the people, and that's usually pretty easy. And whether there's a right to bear arms, or whether what you're trying to regulate falls within the right to bear arms. So that's one area where there's still some ambiguity, and the lower courts are playing with this a little bit. The way that the Second Circuit has framed this, and this is the circuit that we reside in Vermont, is it has said that the Constitution protects the possession of arms that are typically possessed and in common use by law-abiding citizens for lawful purposes, principally individual self-defense, and that are not dangerous or unusual. And that dangerous or unusual is something that goes back to the Supreme Court's language as far back as 2008. And Heller has always said that we're allowed to regulate firearms that are dangerous or unusual. Sorry, was there a question? I thought I heard something.
Yeah, I wasn't clear in my throat, but it was a perfect opportunity to ask a question. John, I appreciate you coming in. I'm curious, and I appreciate the additional perspective just on constitutionality in the Second Amendment more broadly, but very specific to this piece of legislation, looking at Section 3. I'm curious if you have any thoughts specifically on this bill that you could share with the committee.
Sure. Section 3 has to do with the disqualification of somebody who's under certain types of mental health orders. And I think that, again, we're still sort of seeing how cases like this are playing out in courts across the country, so it's hard to give a definitive answer. But I do think that the most recent Supreme Court decision in U.S. versus Rahimi would give the state very strong arguments that this is constitutional. I think what Rahimi said was, as long as you have a court order finding that the person presents a credible threat in some way, that generally they're going to find that the legislation is constitutional because of our history in the country of preventing dangerous people from holding guns. And so again, sorry, go ahead.
Sorry, go ahead, John. You can finish your thought.
Yeah, I was just going to say, again, that's sort of playing out, that covers a lot of territory, and it's a pretty broad holding. But we think the court was fairly clear about that if if there's a finding of dangerousness, and that would be included in a mental health order here, that there would be, that it would be fine to do that, to implement that sort of regulation.
And that's a danger to the public or a danger to themselves? It
Yes.
covers both. Yeah.
Yeah, dangerous person, whether to themselves or to the public.
Okay. Thank you.
And so that sort of thank you for that question. That jumped over a couple of steps for me in the analysis, but that gets to the point. I think that's so. U.S. v. Rahimi was the Supreme Court saying that it's okay to disarm people temporarily who are under court anti-stalking or domestic violence orders. And so as long as there's some finding by a court that this person is dangerous to themselves or others, then that's a fine, justification to temporarily disarm someone. Section 5 of the bill has to do with machine gun ban, essentially.
Section 4,
Oh,
I
sorry.
think, if that's okay.
Oh, sorry, Section 4. I think,
Yeah, Ian,
yes.
before you proceed on that, Ian has a question.
Do you mind just finishing the Bruins test? I think you did the first
Oh,
prong,
sure.
and I just want to hear the
Yes.
second prong.
Yeah, so the first prong is this conduct or this thing that we're regulating covered by the Second Amendment? And for that, we just look at the text of the amendment as informed by history. So that means what would the founders have thought the text of this amendment meant, or what what would the ratifiers of the 14th Amendment in 1868 have thought that this test meant? And then the second part of the Bruin test is if a right implicates the Second Amendment right, then it's the government's burden to show that the regulation is consistent with our tradition of firearms, historical tradition of firearms regulation in the country. And so, that's the part where we have to get into, did they do some sort of regulation that's analogous to the regulation that we're trying to implement? Did they do that at the founding, or did they do that when the 14th Amendment was passed? And that second part is because the 14th Amendment is what applies the Second Amendment to the states.
Excellent. Thank you.
Sorry for the interruption. So that's the Bruin test. I think there's still a lot of the ambiguity has to do with, is a particular regulation fall under part 1 of the Bruin test, or is it part 2 of the Bruin test? Does the analysis of unusual and dangerous weapons, is that a part 1 issue, or is that a part 2 issue? To the extent that we have to look at history to determine whether that whether those sort of limitations apply. I think of particular relevance to Section 4 of your bill is statements going back as far as Heller in 2008, where the Supreme Court has said the Second Amendment doesn't allow you to own whatever gun you want for whatever reason. And what it said was, for example, there's a long history in this country of regulating dangerous and unusual weapons, and it used as an example of a dangerous and unusual weapon a machine gun. And so I think it's long been thought that machine guns can be constitutionally banned under the Second Amendment. And I'm not even aware of Second Amendment cases dealing with a machine gun regulation. I think most of those cases have to do with assault weapons bans at this point. So I think, we'd feel very comfortable defending a case challenging a machine gun ban like what's in Section 4 of the bill here.
Thanks, Chair. And John, I guess going back to Section 3 just briefly, are you aware of any historical precedent of relinquishing rights without orders of hospitalization?
Without an order of hospitalization?
Right.
Yeah, I haven't done a deep dive on this case yet, but I think probably the laws in Rahimi would probably count as historical antecedents or analogs here. And those were the ancient surety laws and the laws prohibiting going about in public armed and dangerous. So I think one of the things that Rahimi said, you don't need a dead ringer. It doesn't have to be an exact duplicate of the current regulation because circumstances change. We're not going to be faced with the same problems. But if you look at the how and why that the founders tried to regulate something, and if the how and why is sort of relevantly similar to the how and why we're trying to regulate something now, that's enough to satisfy the Bruin test. And so the issue of a court finding or the requirement of a court order, there was a court order in Rahimi, but I don't think the court said it was requiring a court order. It just said that as long as there's been some finding of, a credible finding of dangerousness, and it was limiting its actual holding pretty narrowly to that case. So we think that there's, a very good argument that based on Rahimi, something like this would pass constitutional muster.
Okay, and I guess just as a follow-up to that, and I understand that you're speaking in the affirmative for the legislation from your office. But one of the things, and I'm very grateful that you're here because that was one of the things that came up yesterday, and I want to publicly thank the chair too for taking additional testimony and bringing you in, John. But we really haven't heard the contrarian viewpoint from a constitutional perspective. I mean, the Defender General was here. He said Section 3 kind of flew in the face of constitutionality. And I'm curious, if you were to put on a different hat and speak in opposition to the bill, what are the considerations that you would present to us to think about?
Yeah, thank you. I mean, I should clarify, I'm not from the Attorney General's policy shop. That's, there are other people, Todd, who's in the room there, I see is sort of our policy end of things. I'm not here to speak in favor of the bill or against the bill. Sure. I defend constitutional cases, and my job for the Attorney General is to assess laws for their constitutionality. So, I don't. My best reading of the law that's out there right now is that Section 3 we'd have a strong argument that Section 3 is constitutional under Rahimi.
But I guess what would opponents say about Section 3? That's what I'm just trying to get articulated here for us to at least consider.
Sure, I guess they might make an argument that section or that Rahimi was fairly cabined, and so there was a dissent in Rahimi from Justice Thomas, and he said that really the standard should be before you take someone's guns away or implicate someone's Second Amendment rights, you should have a higher standard of proof. But I don't know that I think that was a narrow dissent. Only one of the justices agreed with that, so I don't know that that'd be a very particularly strong position under the law as it currently exists.
Thank you.
Any other questions? Oh, Eric.
The only thing I would add, Eric Fitzpatrick with the Office of Legislative Counsel, maybe this is something John was going to get to anyway, but there's that oft-quoted passage from Justice Scalia in the DC versus Howard decision that was reiterated in Bruin that nothing in these decisions should be construed to cast any doubt on longstanding prohibitions against possession of firearms by the mentally ill. And I believe felons or I think felons are the mentally ill, I think was the language that was used. So that in addition to the dangerous that John was pointing out, I think you've got that as a basis. And I think there is some historical support for statutes that go back a long way historically that regulate the possession of firearms by people who during their own eras were characterized as mentally ill, however that was done. It's just I've analyzed a bunch of these statutes over the years as well in my role. And it's just something that's come up pretty consistently.
Yeah,
As has the notion that I think Matt noted the other day, that this is all about facial constitutionality, right? That there is always the possibility that an individual could make an as-applied challenge that, for example, they were involuntarily committed very briefly and came out and had their mental health restored, and might that go too far in that sort of situation to prohibit that person from a lifetime prohibition? Oh, that's interesting about this statute. The lifetime prohibition only applies if you've also got the violent crime conviction, as opposed to the person who's not under the order anymore. In any event, they can make that claim. Possible that there might be an as-applied challenge, but that doesn't, in my view, affect the statute on its face. Something that conceivably a defendant in a particular case could make a claim, but different situation than how you look at the statute as written.
Thank you.
Yeah.
Any other questions for John, or did you have anything else that you wanted to relay to us, John?
No, that was all. I think Eric makes a good point. There was some language in the original Heller decision, I believe, from Justice Scalia that did, listed sort of people undergoing mental difficulties as one category of people that can be, constitutionally disarmed, at least temporarily, while they're under those disabilities. And so, and I think that Rahimi case relied pretty strongly on that language as well in reaching its holding.
Okay, great. Any other questions? All right. So are we ready I would be ready to take, so we can get this out and have further discussion if necessary. Take a motion. Now let me get my motions right. All right. I want to make sure I get these right. So bear with me a second. While I bring that up. Apologize, should have had this up already. Are you gonna vote? Sure. We haven't put another bill up. Okay, so I will first it'll be a straw poll first. That would be a motion that, bear with me. That we approve amendment draft number 3.1 to H606. I'll take that motion. For a second. Second. Well, that's right. So this is just,
No, even on a vote, Mason's rules, not that I'm an expert on rules, Mason's rules, you know. Eric can probably correct me. No, okay. Mason's rules, you don't need seconds, Robert's rules, you do.
I think it's been become practice.
Yeah, no, absolutely.
Um,
You're on the side of caution.
so coach, are you, with us so we could see you instead?
Just there, like 3 seconds ago.
He's muted, so.
Coach, you're muted if you're, talking to us. Somebody, we just lost somebody.
That was John Rose dropping.
Oh, that's Joe. Okay.
Yeah, I'm happy. We can take a brief.
No, we.
Call him. He was just on.
I knew he was on a subject song. We're gonna recess for a minute.
Oh.
Yeah, please, or.
I was gonna say.